Paula Reed, I know you've been listening to this decision. What have we heard?
We have. Of course, this is not a thumbs up, thumbs down. This is a complicated decision. We just got it here. It's an opinion from Chief Justice John Roberts, finding that former presidents are entitled to absolute immunity for official acts, but not for unofficial acts. So what does that translate to? Well, this is something we saw that was sort of signaled in oral argument, because what this means is that the former president cannot be prosecuted for anything that was officially part of his job when he was in office. And that's significant because even his own lawyers conceded during oral argument that not everything that is alleged in this indictment was an official act. So now the question is, what does the special counsel do here? He could potentially try to cull down this indictment to a more narrow one, just focusing on unofficial acts, and then try to proceed with this case. Still an open question, though, about whether even a slimmed down case could go before the election.
All right, friends, Adam here. So what just happened, guys? A 5-4 Supreme Court ruling through the emergency shadow docket just declared Trump has zero immunity from criminal contempt of court, obliterating the central pillar of his legal defense and giving Congress a direct, legally binding green light to pursue impeachment and removal.
Garrett, we're coming on the air with breaking news from the Supreme Court, where the justices have just ruled on whether former President Donald Trump has absolute or qualified immunity for conduct involving his official acts during his time in the presidencies. The former president and his defense team made the argument that a president, not only former President Trump, but any president, has absolute immunity, this after he was criminally charged with plotting to overturn the results of the 2020 election. The import of this case simply cannot be overstated. How the justices' rule could well define the parameters of power of the American presidency and have something to say about the future of our very democracy. CBS News chief legal correspondent Jan Crawford has been reading the ruling. Jan, what do we know?
We know this is a 6-3 ruling written by the Chief Justice that says flatly presidents are immune, absolutely immune for their official acts. That means acts that they take under the arbit of their office as president. But, and here's the big but and why it's important for Donald Trump, they do not have that kind of immunity, as you said, for their unofficial acts.
To fully grasp the nuclear fallout of this moment, you have to rewind and understand the precarious house of cards that Trump's legal team had constructed over the course of endless court battles and public pronouncements. For months upon months, the central thesis of his defense against every inquiry, every subpoena, and every judicial order was a wall of absolute protection. His attorneys stood before judges and argued with a straight face that a sitting president exists in a bubble of such extraordinary privilege that the court simply cannot touch him, cannot prosecute him for contempt, cannot enforce a gag order, and cannot compel him to comply with the rule of law.
We are now 270 days away from the midterms. And right now, a whole lot of Republicans are worried that the president's priorities are going to cost them control of Congress in November. Some of his allies on the Hill think that the president doubling down on the wrong messages is certainly hurting them. For example, this morning, only one day after he told NBC News that a softer touch was needed on immigration, he attended the National Prayer Breakfast and said this.
Things are happening in our country right now, and we have to get the bad ones out. We have to do it. We can't let that happen, and we're being very tough on law and order and crime. If they've killed in another country, they're not going to be the best of citizens. And they're rough people. Remember in the campaign, I used to say that their criminals make our criminals look like babies. It's true. These are some of the meanest, most vicious people. They only gave us the worst.
They painted executive authority as a sword that supersedes the gavel of the judiciary, insisting that no federal judge has the constitutional standing to hold the commander-in-chief accountable for telling the courts to go to hell. That entire fantasy, that entire magical shield of untouchability, has just been vaporized by the very institution Trump spent years trying to pack with loyalists. The Supreme Court looked at the argument that presidents are above the law and delivered a definitive, bone-chilling response. Absolutely not. The composition of the vote is perhaps the most lethal aspect of this entire ordeal for Trump's political narrative. This was not a partisan hack job by the liberal wing running roughshod over the rule of law. This was a 5-4 ruling where the deciding vote was cast by Chief Justice John Roberts. That is the moment that rips the floor out from under the witch hunt talking point. Roberts, a conservative stalwart appointed by a Republican president, a man who has bent over backward in prior cases to protect the institutional reputation of the court and conservative prerogatives, sided with the 4 liberal justices. He broke ranks. He looked at the logic of Trump's absolutist immunity claims, weighed them against the Constitution, and decided that the damage of allowing a president to mock judicial authority was too catastrophic to tolerate. When the Chief Justice sides with the opposing ideological bloc on an emergency petition like this, it tells you everything you need to know about the sheer legal weakness of the president's position. The immunity strategy is now dead. It is a corpse, and no amount of rhetorical embalming by his press secretaries can bring it back to life. What makes this legal bombshell even more extraordinary is the specific procedural mechanism the court used to detonate it. We are talking about a shadow docket decision, an emergency order designed for time-sensitive technical matters that usually slip under the radar without major public fanfare. The shadow docket is typically where the court handles administrative trivia. It is not the arena where fundamental questions of presidential power and the impeachment authority of Congress get hammered out. But the Supreme Court decided that the constitutional crisis unfolding before them was too urgent for the slow-walking merry-go-round of full briefings, amicus curiae submissions, and oral arguments spread over months. They acted like a surgical strike team. They bypassed the normal procedures because the situation was an emergency. A 5-4 ruling, without a lengthy written opinion, delivered like a thunderbolt, stating the outcome with crystal clarity. They ruled that presidential immunity does not extend to criminal contempt violations. They ruled that courts have the power to enforce their orders against all persons, including the person occupying the White House. And most crucially, they explicitly affirmed that Congress wields the impeachment power as the constitutional remedy for a president who defies those very court orders. This is a direct validation of everything Judge Boasberg has been doing. For days now, the tension between the judiciary and the executive branch has been ratcheting up to a breaking point, with Boasberg threatening to direct federal marshals to arrest officials who obstruct his orders and holding the contempt hammer high over the administration. Trump's legal representatives responded with sneering dismissals, claiming that the judge was overstepping his bounds and that the executive branch was immune from such aggressive judicial enforcement. Well, the Supreme Court just handed Judge Boasberg the keys to the armory. By ruling that no such immunity exists, the High Court has deputized every federal judge in the country to enforce compliance against administration officials, up to and including the commander-in-chief. The courts can march federal agents into the offices of defiant bureaucrats. They can order arrests. They can hold people in contempt without worrying about the legal ground being pulled out from under them. This ruling is an institutional power-up for the judiciary at the exact moment the judiciary is in a cage match with the executive. The immediate political shockwave is already manifesting in the halls of Congress, where the machinery of removal is grinding into gear at a velocity that seems ripped from a political thriller. The Democrats, primed for this moment by years of pent-up legal frustration, have pounced on the ruling with a legislative ferocity that signals the endgame. There is now a resolution rocketing through the House of Representatives, drafted within the narrowest window after the Supreme Court's gavel fell, that demands an impeachment vote in an astonishingly short time frame. They are talking about forcing a floor vote in just 72 hours. The goal is to trap every single member of Congress in the hot seat, to hold the vote while the Supreme Court's ink is still metaphorically burning the pages of the Constitution. The charges being leveled are not vague political grievances. They are mapped directly onto the Supreme Court's legal rationale. We are talking about oath-breaking, the deliberate sabotage of the Pentagon's chain of command, flagrant judicial obstruction, and criminal contempt. The resolution is structured as a direct congressional execution of the Supreme Court's ruling, a seamless transfer of legal authority from the bench to the legislature. The strategy behind the 72-hour blitzkrieg is a masterclass in political speed warfare. The Democrats have analyzed the board and realized that time is the enemy of accountability. If they allow this to drag out, the media cycle will churn, the collective memory will fog, and the Senate Republicans will have time to build procedural walls and whip votes against conviction. By moving immediately, by forcing a House vote while the country is still shell-shocked by the image of Roberts siding with the liberals, they are leveraging the momentum of institutional legitimacy. Every Republican in the House will have to cast a vote that will define their career. They will have to look at a Supreme Court ruling that says, this is constitutional, and then decide whether to vote against impeachment, thereby announcing to the world that they stand not with the Constitution, but with a man adjudged to be in contempt of the judicial branch. It puts every single one of them on a knife's edge. For those in swing districts, this is a political nightmare scenario where the wrong vote on the floor could end their careers come the next election cycle. Of course, the volcanic political pressure is not contained to the marbled chambers of the Capitol Hill. It is spilling over into the streets in a display of raw chaos that signals just how high the stakes are. Reports are flooding in of mass unrest, with riot police clashing against crowds of supporters who have realized that the Supreme Court ruling is not a political opinion. It is a terminal diagnosis for the Trump presidency. The optics of this are devastating for the administration's claims of a silent majority marching in orderly support of the rule of law. Instead, the world is witnessing desperation boiling over because the base understands the math. The game has changed. The immunity shield that they were promised was unbreakable has shattered, and now the only thing standing between Trump and removal is a political vote. The chaos at the Capitol is the sound of a movement hitting the hard wall of constitutional reality. It is a visceral, angry reaction to the realization that the system, designed by the founders to endure demagoguery, is starting to pull itself back into alignment. The unfolding drama is also casting a harsh spotlight on the specific triggers that brought us to this precipice, including the boiling tensions surrounding high-profile officials like Kash Patel and the dark undercurrents of files that the administration would prefer to keep buried. The legal deadline for Patel to face the consequences of his own defiance is ticking like a time bomb, intersecting perfectly with the Supreme Court's ruling. The judicial pressure on the FBI director and the legislative pressure on the president are fusing into a single, unified constitutional offensive. The Supreme Court ruling validates every threat Judge Boasberg made about sending marshals into Patel's office. It turns those threats from the angry whispers of a frustrated judge into the lawful commands of a judiciary backed by the highest court in the land. The walls are closing in from all directions. The administration is not just fighting a one-front war against Congress, it is fighting a judicial insurgency backed by the Supreme Court, and its soldiers are starting to realize they might actually go to jail for taking a bullet for the boss. The specific contents of House Resolution 415 reveal a legislative body that is not messing around with ambiguous language. They are going for the jugular with articles that detail a systematic breakdown of presidential conduct. The oath-breaking charge gets to the very heart of the matter, alleging that the president has violated his singular constitutional duty to take care that the laws be faithfully executed. By obstructing the courts, he has broken the oath of office. The Pentagon interference charge ties into the broader narrative of weaponizing the military for political cover and leaking sensitive information to muddy the waters, a direct assault on the nonpartisan traditions of the armed forces. The judicial obstruction article is practically a direct quote from the Supreme Court's ruling, charging that the president's systematic refusal to comply with court orders is a direct attack on the separation of powers. And the criminal contempt charge is the legal spear tip, using the Supreme Court's own language to declare that the president's behavior meets the standard for removal. These articles are not a fishing expedition, they are a targeted missile strike. Let's dive deeper into the seismic importance of Roberts' defection from the conservative bloc because it is the political keystone that holds up the legitimacy of this entire crisis. For decades, John Roberts has been obsessively concerned with the perception of the court as a nonpartisan institution. He writes opinions that hedge and slice the law in ways designed to avoid the appearance of the court being just another political body. For him to abandon that caution on the shadow docket, to take a vote that explicitly invites Congress to impeach a sitting president, is proof that the evidence of contempt and the danger of unchecked executive power were too blatant for him to ignore. It says that even a conservative legal titan could not find a good faith argument to grant Trump immunity. If the immunity argument had any merit, Roberts would have found it. He would have crafted a narrow, procedural compromise that protected the presidency as an institution while carving out some minor path for the courts. He didn't. He voted for the bomb. This single vote deconstructs the entire Republican messaging strategy that frames the legal system as a deep state weapon. You cannot credibly argue that John Roberts, the architect of the conservative legal renaissance, is a deep state operative. The shadow docket nature of the ruling adds a layer of dramatic finality that a regular opinion would have lacked. Usually, a Supreme Court ruling provides a hiding place for dissenters, pages of footnotes that senators can clutch onto to justify a vote against removal. The court has denied them that escape hatch. There is no complex dissenting opinion to parse. There is no silver of ambiguity to exploit. There is just a 5-4 decision and a crystal clear bottom line. The justices have essentially handed the Constitution back to the American people and said, "We've done our job. Now you do yours." This forces the Senate into a binary, terrifyingly simple decision. They are not voting on whether a particular evidentiary standard was met in a lower court. They are voting on whether to listen to the Supreme Court of the United States. To ignore the ruling and vote to acquit Trump is to effectively nullify the authority of the judiciary, pushing the country into a full-blown constitutional breakdown where the executive simply ignores every other branch. That is the stake for Republican senators. It is no longer a vote about liking Trump. It is a vote about whether to burn the Constitution to keep him warm. The political calculus for those senators has shifted from abstract partisanship to survival instinct. The Democrats need a significant number of them to flip, and while that threshold is high, the ground is shifting beneath their feet. The riots at the Capitol, while driven by the president's base, also expose a terrifying instability that many senators find abhorrent. The images of chaos, the mass arrests, the screaming faces of protesters breaking through barriers, all of this is the fruit of a movement that refuses to accept legal reality. For establishment-minded Republicans, chaos is bad for business and bad for governance. They are being asked to choose between a president who is now a confirmed legal liability and the stability of the republic. The Supreme Court decision gives them the moral cover to switch their votes without looking like they are surrendering to the Democrats. They can claim they are siding with the Chief Justice. Moreover, the world is watching. Foreign markets are recoiling from the instability of a nuclear-armed power having a constitutional meltdown. The dollar, the bond market, international alliances, all of them rely on the assumption that American law holds firm. This ruling is trying to reassert that stability, and Senate Republicans will be under immense pressure from the business community and the donor class to end the madness. As for Trump himself, the psychological and political impact cannot be overstated. The man has built his entire identity on the premise that he is the ultimate winner, a force of nature that no system can contain. The Supreme Court, an institution he packed with 3 justices, is now the instrument of his potential annihilation. The very justices he held up as trophies of his political power have declined to lift a finger to protect him from a criminal contempt ruling. The fear inside the West Wing must be palpable. The usual playbook of attacking the judge on social media will not work here. You cannot deplatform the Supreme Court. You cannot fire them. They have life tenure. They have spoken. The only option left is a raw, ugly political fight in the Senate, forcing loyalists to walk the plank for him. This is the moment where the transactional nature of his political relationships will be tested to the breaking point. So, where do we go from here? The path forward is no longer a matter of if the House impeaches, but when. The 72-hour war clock is ticking. The House managers will present a case that is legally bulletproof, anchored by the Supreme Court's own language. Once the House votes to impeach, the theater shifts to the Senate chamber for a trial that will be the most consequential in American history. The entire weight of the constitutional order will press down on that chamber. The Supreme Court has already ruled on the legal premise. The Senate is simply the executioner or the absconder. For Republican senators, the choice will be stark. Do they stand with the Chief Justice, with federal judges, and with the rule of law? Or do they tie their legacy to a president who has been legally defined as a criminal contempt violator? The implications of their decision will echo for centuries. If they fail to convict, they will have gutted the separation of powers and told every future president that the Supreme Court is impotent. If they convict, they will have reaffirmed that the American experiment can withstand a tyrant's tantrum. This is the constitutional crucible. It is the moment the founders prepared for, where the limits of power are tested not with guns and artillery, but with parchment and principle. The Supreme Court has held up its end of the deal. They have placed the sword of impeachment directly on the table. It is now up to Congress to pick it up. The coming days will be a whirlwind of backroom deals, frantic whipping, and raw political terror as the vote approaches. The nation is holding its breath. The riots, the rhetoric, the threats, they are all the death throes of an ideology that believed it was above the law. But the law has arrived. It came not with a partisan bang, but with a 5-4 vote in the quiet of the court's emergency docket. The game is over for the immunity shield. The question of whether Trump is scared is irrelevant. He should be. The real question is whether the Senate chamber is filled with enough profiles and courage to finish what the Supreme Court just started. Everything changes now. The gavel has fallen, and the echo is impeachment.